Hello and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law. And, well, hey, anything else we want to talk about. Today is going to fall squarely under the estate planning and elder law category. This question we're going to talk about today is coming from a lot of people in the last few months asking it, and we actually now have inserted it into our current workshop just as a way to reiterate it. When a lot of people ask, you know that it's a time to incorporate it into the workshop, but also do a podcast on it. So that is what we're going to do today. Before we get into the meat and potatoes of the podcast, I do want to talk and just remind everybody that we do weekly workshops at Belomo and Associates. We do workshops on estate planning and elder law and the pre-planning context on a weekly basis in York and also in Lancaster. And we do crisis planning workshops. Those are workshops for people who have loved ones who are either already in a nursing home or who may need a nursing home in the near future. We also have special needs workshops. Those we do mostly in the community, and we also have a link if you're not able to attend one in the community. And for people who are going to be working with our office, we have probate and trust administration workshops to teach the executor exactly what his or her responsibility is and what they need to do in order to fulfill their duties. So please, if any of those are of interest and you're looking to get information, please give us a call, 717-845-5390, or check us out on the web at www.belomoassociates.com. And we look forward to seeing you at one of our workshops. If the dates don't work or you're not able to come in, we have all of our workshops on links that we can send you as well so that you can watch them in the comfort of your home. All right, so on to today's podcast. I'm looking forward to this. Ways to receive an inheritance. So the way or you could turn it and say, what are the ways that you could pass on your estate to individuals? But the way that it's being posed to us is, what are the ways that I can receive an inheritance from a loved one? So that's how we'll sort of couch it today, but please know that it could be reversed as well. And you could be essentially asking the reverse question, which is, how can I pass on my wealth to family members or to other individuals? And what are the different ways to do that? All right, so ways to receive an inheritance. You can have an asset that is jointly owned. So if I own an asset joint with another individual and one of us dies, it automatically transfers to the other person. Okay, so we did do other podcasts where we talked about property ownership specifically and the different titling. For the purpose of right now, I'm just simply mainly talking about financial assets that we own joint. Although, yes, there is a whole other podcast about real estate. So if you're curious about real estate, please watch that show as well, which is also a really good one, as it certainly will clarify the different terminology with real estate as how you can own it jointly. But for today, we're going to talk about joint, really kind of with rights of survivorship, where if one dies, it automatically transfers to the other, okay? And in the financial arena, basically, if you own an asset joint, that is how it occurs. It will transfer automatically. All right. That just simply is, I own a joint with someone else, I die, they die, it automatically transfers to the other individual. Now, remember, inheritance taxes do apply. So it's only going to be taxed at half the value because it's presumed that I own half and you own half. Now, obviously, if there's three of us, then the percentage just changed just based upon how many people own it jointly. But if there's two, inheritance tax would be 50% when the one dies at the rate that is applicable. Remember, the current rates in Pennsylvania, 0 to a spouse, 4.5% to lineal descendants, children, grandchildren, parents, grandparents, 12 to siblings, 15% to anyone else in the world, including those lovely nieces and nephews. So, but only half of it would be inheritance taxable because we own it joint if there's two of us, and then of course 3 would be a third, and then 4, and so on. Okay, that is a way to own an asset. Another way to own an asset to transfer on or to receive an inheritance or to transfer on wealth would be that you own it in your name alone. So it is just in my name. I have no beneficiary designations. I have nothing on it. It just is in my name. Now, what does that mean? That means that my will is going to govern where the asset goes. Because it's not joint, it can't pass automatically. Because it's in my name alone with no beneficiary designation, it also can't pass according to that because it doesn't have one. There are some assets and accounts that simply do not allow for beneficiary designations, such as transfer on death, payable on death, in trust for. There are institutions that we have found that won't allow them. And if that is the case, then into your name alone is one option for that scenario. The terms of your will are going to govern what happens to those assets. And of course, the will must go through probate. Probate is the state's process by which we carry out your wishes for assets that are in your name alone. It is the state's rulebook. It tells us what has to occur. It tells us what the timelines are. It tells us that you can advertise to creditors from the date of advertising. They have 1 year to come forward. You have 9 months to pay the inheritance tax. The inheritance tax department typically right now is taking about 6 to 8 months to return the inheritance and provide the appraisement that says whether the taxes were paid correctly and whether any additional taxes are owed. Then the process tells us that there are notices that have to be provided. There are things that have to be done. And then, of course, the returns have to be filed as well. So that is just the rule book by which the state says what does probate look like when you are carrying out a will for assets that are in your name alone. So far we've talked about two different ways to transfer wealth or to receive an inheritance. They are joint, where there are other owners, or also in your name alone. Now, you could also have an asset in your name alone, but that you have a beneficiary designation on it, right? Retirement accounts, life insurance. I already mentioned payable on death accounts, transfer on death accounts, in trust for accounts. Payable on death is usually with savings bonds. Transfer on death is usually with brokerage accounts, and ITF is usually in trust for is usually with bank accounts. That simply means at death for an asset that is in your name alone, it will automatically then transfer to whoever you list as the beneficiary. Now, also important to mention that it is still included for inheritance tax purposes, assuming that the asset itself is included for inheritance tax purposes. So, testing your knowledge, what is the one asset that is not subject to Pennsylvania inheritance tax? Life insurance, right? Life insurance is wholly exempt. So that just simply means that the beneficiary receives the money upon your death after filling out a form and after, just proving their identity and also proving that the individual has passed away. And then that money will get paid directly and is not subject to inheritance tax. Other than some very minor exceptions, everything else is subject to inheritance tax. Pennsylvania does get their share of it. And the rate is, again, applicable based upon the individual receiving it. So, just to reiterate, inheritance tax, 0 to a spouse, 4.5% to lineal descendants, children, grandchildren, parents, grandparents, 12% to siblings, 15% to anyone else in the world, including those lovely nieces and nephews. So you have an asset in your name alone, you have a beneficiary designation, you die, it transfers automatically to that individual. You don't have to go through the probate process for that. You don't have to do anything else necessarily. Now, another way that you can transfer wealth, in addition to joint in your name alone with a beneficiary designation, is going to be through the distributions of a trust or through a trust. So a trust is a contract between three parties. The grantor, the person who creates it. The trustee, the person who controls it. The beneficiary, the person who receives it. It's just a legal document that sets forth the obligations of those three parties to each other, and what the rules of the document are. We have spent a lot of time on the radio show talking about trusts and the difference between revocable and irrevocable, and how the trusts that we're using are not tax trusts because we don't have the federal estate tax issues like we used to. Currently, the federal estate tax limit is 12.92 plus 12.92. Yes, it is set to go back to 6 million, or there too, there around. It's 5 million plus inflation. We're guessing it's going to be right around 6 million in 2026, as long as the law doesn't change. So stay tuned on that, and we've certainly talked about that ad nauseum, and we will continue. So hopefully this is all sounding at least as a little bit of repeat for the listeners who have listened to all the other shows. So we're not doing the tax trust. We're not doing that stuff a lot at all anymore because of where the federal estate tax limit has gone. But for the purpose of today, I just want to talk about the way that the distribution occurs. So if the asset is owned in the name of a trust, right, it really doesn't matter if it's revocable or irrevocable. The person who creates it in the document will provide for who's it going to get it when you pass away in the trust, right? So again, we'll call it the beneficiary, the person in the trust who's going to receive it after death. So they name them in the trust document, and then the asset actually gets titled in the name of the trust. So just by way of example, if I have a trust, and let's say my wife and I create it, it would be Jeffrey and Whitney Belomo, trustees of the Belomo Family Trust, dated, right, whatever date. What that tells me is that Jeff and Whitney created the trust. Jeff and Whitney control the trust. Again, I'm just talking about trust in general, not any specific types, because it really doesn't matter. All trusts will avoid probate. As long as they're funded, as long as the assets are titled in the name of the trust, they will avoid probate. The only way that that won't occur is if the asset is not owned in the name of the trust. So as long as it's owned in the name of the trust, now the trust document controls, and it will tell me who will receive it after death, the beneficiaries. Now the person passes away, or the people pass away who are the grantors, and they look to who the residuary beneficiaries of the trust are. And then the assets will pass to that person. Now, the taxation of it does depend on, from inheritance tax, what type of trust it is. But since we agreed that we're not talking about tax trusts, it would be included for inheritance tax purposes. That is both the revocable trust that we use and the asset protection trust that we use. But the good news is we get the step up in basis, right? So that means that the beneficiary of the trust receives it after the death. They pay whatever the applicable inheritance tax rate is. If it's a child, it's 4.5%. But now the basis to the child receiving it is the basis, the fair market value on the date of death. So if the fair market value on the date of death is $200,000, that is what the beneficiary receives it at, and therefore if they sell it for $200,000, 200,000 minus 200,000 is zero, which means that there is no capital gains tax implications because they received that step up in basis because it was included for inheritance tax purposes. So that is the fourth way to receive an inheritance or to give away wealth. Let's just recap them one more time. Joint, individually with a beneficiary designation, or through a trust. Those are the four ways to receive an inheritance or to give wealth. Now, the significance of this is that the mistake we see people making all the time is that they don't understand how those four come together, how those four jive, how those four interact with each other. So what I mean by that is, if you do a will, remember, wills only govern what is in your name alone at the time of your death, not something that is jointly owned, not something that has a beneficiary designation, and not something that is in a trust. So what that means is, if you do a will and you have joint assets, the will doesn't govern it. If you do a will and you have assets that have beneficiary designations on them, the will doesn't govern it. If you do a will and you have assets in your name alone, but you also have a trust, the will that you do does not have anything to do with the trust document and how the distributions were made through the trust. So the significance of this is you can't just do a will and not work with your attorney, work with your financial professional to make sure that those are all tied together. You want your estate plan to be coordinated. You want your estate plan to be a plan and not just documents, right? So what you do is, yes, you can still do the will, but then you have to check all of your beneficiary designations. You have to check your joint ownership. You have to check your trusts. Now, maybe you want them to go differently. Completely fine. But what you don't want to have happen is to make a change in the will and think that that by itself now changes what happened in the trust, changes what happened in the beneficiary designation, or changed what happened in the joint ownership. It doesn't. They are different. They transfer differently. So people will say, well, doesn't this trump that? It's not that one trumps the other or one's better than the other. They're just different, right? Wills govern assets in your name alone. Joint assets govern joint assets. Beneficiary designations govern beneficiary designations. And trusts govern trusts. There are 4 ways there. They go differently. They have nothing to do with each other. You have to coordinate your plan, right? So one of the things that we are doing in our office is not only working with the financial professional, we actually have in our fee agreement that you give us permission to work with your financial professional. We need to be able to call the office if we have questions. We need to be able to make sure that the plan coordinates together so that you don't have different things out there haphazard. So not only do we want to work with them, but we then want to coordinate the entire plan together. For those of you who have been to a workshop or listened to the show, you know that one thing that I have been preaching from the mountaintops is that it is very hard for me to come up with a scenario where protecting the asset for the spouse or protecting the asset for the child isn't the way to go. My joke and my phrase that I always use is, you love your spouse and you love your child way too much to leave the assets outright. So the problem with beneficiary designations, the problem with joint ownership, the problem with even an asset in your name alone that goes through a will that only provides for outright distributions, is that now all of those assets just go directly to the individual, now subject to their divorce, their nursing homes, their car accidents. When assets go outright to an individual, anyone in the world can take it, right? Creditors, predators, you name it, it can be taken. So what we do instead is we coordinate all of those together so that in a plan that we're doing, we'll have essentially the will pour into the asset protection trust or into the trust after death that provides for all the trust distributions. We'll have the beneficiary designations pour over into the asset protection trust or into the trust for the individual after death. We will have the trust pour into or go into a trust for the benefit of the spouse or for the child. So all of it is ending up in the trust for the child or the trust for the spouse. And what that allows us to do is to immediately protect the assets after death. Transfers on death are not subject to a look-back period. If an individual comes into our office to do an asset protection plan, they have to wait 5 years for it to be fully protected. And remember, if you're doing an asset protection trust, you cannot take retirement assets and put them into the trust after or during life without triggering 100% of the taxes. So what we do instead is we have the beneficiary of those assets be the trust for the benefit of the spouse. If it's a retirement account, we'll call it a spousal only retirement trust. If it's a trust for a child, we'll call it a separate share trust. What it is doesn't matter, right? That's just words. The meaning is those assets will pour into a trust for the benefit of those individuals. And if it happens to be a retirement account, with minor exception, you can protect the asset itself from long-term care costs and creditors and those types of things. Now, in light of the new Secure Act, there are some things that have to occur. We have to distribute minimum distributions out. There's some things that have to be done, but there are other options, which is why we do provide flexibility in the documents so that we have different layers depending on the situation. We want to make a game time decision as to what's best for the family, and we're only going to know that when the person passes and we're able to evaluate the situation. So all of it is basically pouring into the trust for the benefit. And then by doing that, you're avoiding the 5-year look-back period. You're avoiding the fact that you'd have to liquidate the retirement to get it into the trust for the benefit of the spouse and or for the individual. And also what you're doing is you're now allowing only the spouse to receive it, only the child to receive it. And in the spousal situation, you're now able to limit the ability for that spouse to take that asset and then add a new spouse as a joint owner or add a new spouse as the person who ultimately receives it. What most families say to us is, look, I want my spouse to enjoy their life. I want them to spend the money. I want them to live the lifestyle that they want to live. But ultimately, I don't want the money to go on to the new spouse or onto the new partner or onto the new friend. I want to make sure it stays in the bloodline. I want to make sure it stays with the family. Only they get it during their life. Only they enjoy it. But it's not a situation where it can just be given. Whether it's intentional or not intentional, when people end up together in future marriages, they could be together 20, 25, 30 years, maybe longer than what the original marriage was. But oftentimes the children end up not getting anything at death and the new spouse gets those assets. And what we hear a lot of clients tell us is, look, what he or she does with their assets, completely their business. But the assets that I was able to pass to them, whether it be retirement or insurance, I do just want to make sure that it ends up with the kids. If they spend it during their life, great. By all means, spend away, have fun. Please don't just give it to a new person that I don't know and that you end up spending time with in the future. Let's make sure we provide for the kids. And honestly, I don't know that I've ever had anyone who didn't agree with that and go along with it. But the importance of it is that you have to understand the 4 ways to receive an inheritance and also the 4 ways to transfer wealth so that you can understand how they have to come together. You can't have 4 separate plans. You can't work with your advisor on the beneficiary designations, the lawyer on the assets in your name alone, the lawyer on the trust, and then just your bank officer or someone on the joint ownership. All of it you need to look at together. And in some cases, depending on what the plan is, maybe you undo the joint, put them into the proper distribution channels, such as the trust or such as, other assets. The ultimate plan is you got to get it at the end to jive together to get the assets where you want them to go. But that may mean some changing of how things are titled, whether it be the ownership or whether it be the beneficiary. So just as a little recap, the ways to receive an inheritance or transfer wealth are joint, individually through a will, individually with beneficiary designations, or in a trust, and then they're distributed according to the trust distributions. You want to make sure that your plan ties together. You want to make sure that all of your professionals know the plan, and you want to take a few minutes after this show and check your beneficiary designations, check your joint ownership, check your will, and also check to see if you have a trust and make sure that all of those are pointing to the same direction. If you have 3 kids and you want everything to go to the 3 kids, make sure that all of them say that. You can't say one thing in one and expect it to change something else. They have absolutely nothing to do with each other, and therefore they won't help the other asset transfer. It has to be that specific asset. Man, I had a lot of fun today. This was a Wonderful topic that's been coming up quite a bit in regards to ways to receive an inheritance, but also ways to receive or transfer wealth. Just a point that I want to make before I wrap here is that it is important to have all that tie together. And if you have an individual in your family with a special needs who potentially may in the future receive public benefits, you cannot leave the money outright to them. You cannot leave them as a joint owner. You cannot leave them as a beneficiary designated owner. You cannot leave them outright in a will or outright in a trust. They have to go into a special needs trust for the benefit of the individual with the disability. And that's where people get hurt when they don't understand the ways to receive an inheritance. Make sure those assets get into that special needs trust. We would love to educate you. If you learned a little bit today and you're looking for more and you want more information about any one of these topics that we touched on, please give us a call, 717-845-5390. We have workshops in pretty much every area of estate planning and elder law. We have them live. We have them live on Zoom. We have them on a link. We have them all different ways. We even do them out in the community. So certainly plenty of ways to get more information. Check out our radio shows. Check out our podcast. Check everything out. We are certainly out providing as much information as we possibly can. We hope you enjoyed today's episode of the Red Wagon Estate Planning and Elder Law Show. We look forward to seeing you next time. Until then, we'll see you real soon.